Okay, so rolling right into this, and we have Adrian Karborani of Robert Allen Law with us right now. He's an associate at the firm where he works in corporate yacht law and litigation departments, focuses on yacht transactions, litigation, secured maritime finance, corporate law, and he's going to talk to us about contracts, MIBA, IYBA, and YABA, I think it is. So let's hear it for Adrian Karborani. Thanks, Mike. Thank you, Mike.
Good afternoon. So before I begin, I'd like to thank Paul and the IYBA for inviting me to speak here today, and to our sponsors who enabled events like this to take place. I would also like to thank Mark Norman from our firm, who helped me put together this presentation. And I'd like to share something with you guys. You know, I got up this morning and I thought, gee, Adrian, you're one lucky dude to have the opportunity to get up in front of this room of well-respected professionals and give this presentation on contracts. Thank you. I mean, really, I could have easily been one of you, stuck listening to me for the next 30 minutes about where to put a comma. I'm just kidding. It's not going to be that entertaining. So without further ado.
We thought we'd roll out a once-in-a-lifetime business opportunity.
Happy birthday, Derek.
Music.
Prestige. Worldwide. Why?
Prestige worldwide.
So I also got up this morning and thought, I'm probably never going to have the opportunity to put Will Ferrell in a presentation again. And I was really excited to share that with you guys. Anyways, in all seriousness, today's presentation, I thought we would narrow the scope a little bit. Worldwide contract analysis seems a little bit of a large topic to cover in 30 minutes. So I decided we should focus on just a few contracts, specifically the most popular purchase and sale agreements in our industry, the IYBA, the MIBA, and the YABA. So my goal during our time together is to educate you a little, or as the case may be for some of you, to give you a refresher on the benefits and pitfalls of the different forms. I won't be able to highlight everything, all the differences, or all the protections, but I will try to cover the points that I think are the most important for you to be aware of, and so you can properly educate your clients. That being said, as a broker, it helps to have a knowledge of the basic difference between the forms, and it also makes you look good in front of your clients when they ask these questions. And I guess another bright line rule I'd like to establish here is, since we're going to be discussing three different forms, I'll be using the IYBA as the base form because it's the best. Where's Paul? And the other ones will be comparing to that. And that's not only because it makes things easier to highlight and to follow along, but because you guys probably have the most exposure and experience with the IYBA form. With that said, let's kick things off. And the first thing that I want you to notice is the difference in the page numbers. The IYBA is 4 pages, the YABA is 5 pages, and the MIBA is 11 pages. Right? Oh, so you know there's this joke about lawyers not knowing how to do math, right? And I think it's true. But in this case, the MIBA form comes with 8 pages as part of its standard package, and then you have a 3-page addendum, bringing the total to 11 pages. So is that a big deal? Seems like it's not, but I mean, isn't it easier for you as the broker to read all the legal mumbo jumbo in 4 pages rather than 5 or 11? I mean, yeah. Maybe. I mean, you're the broker, right? You're supposed to know what's in these contracts that you're presenting to your clients and what they're signing. On that point, let me add that the MIBA is written in English, but if you've read it, you'd swear that it wasn't because it's written in UK English and legalese. So anyways, that's what I would call the superficial contrast of the forms. Now let's get to the meat and potatoes, if you will, the substance. To be clear, reading through these agreements is tedious. It's a lot of boring legal stuff, and it's actually hard to stay awake reading one straight through. Trust me, I know, I did it the other day. I'm going to do my best to keep you awake, but I make no promises, expressed or implied, as the lawyers would say. So this is gonna be our roadmap for what we're gonna be discussing today. The points that I'm gonna try to isolate and focus on for you guys. There aren't too many, as you can see, but they're important, and they have significant legal effects on the deal. And as we go through these differences, I'm gonna try to highlight why it matters for your clients and how it affects whether you, the broker, get paid. Okay, so let's start off at the beginning of the deal with the deposit. Specifically, when is the deposit due? Who holds it? And how much is required? Under the IYBA, deposit's due within 3 business days of the seller executing the contract. The selling broker will hold the deposit, and the amount of the deposit is whatever the parties agree to. It gives you flexibility. Under the IYBA, the deposit is due upon execution. It's held by the selling broker, and it's whatever you guys agree to, like the IYBA. Now the IYBA here, it's due within 4 banking days after the buyer's signature. It's held by so that means even if the seller doesn't countersign, it is held by the stakeholder. More on that in a bit. And it's a fixed 10% of the purchase price. So let's dig in here a little bit and see what this means. Under the IYBA, the contract signed by the seller, we have a deal. We do not need to wait for the deposit to hit. The selling broker holds the deposit, and the amount of deposit can be negotiated. It's pretty flexible. Under the IYBA, things are a little different because the deposit's required upon execution, and the IYBA contains a time is of the essence clause, which in layman's terms means that upon any party's breach of a deadline, it's deemed a material breach of the contract, and you could potentially have a buyer that's in default. So when considering the deposit, if it's not made upon execution, then the contract is already dead, or worse, as I just explained, the buyer's in breach. Here you have to be careful because failing to tender the deposit with the offer could be used to give the seller the ability to back out. In essence, the deal could be dead just as you got it off the ground. So if you're using a IYBA, I'd recommend an amendment to give the buyer at least 3 business days to make the deposit. And like the IYBA, under the IYBA, the deposit's held by the selling broker, which is good because in the event of a dispute, you have possession of the deposit. And that matters because as I'm sure as you've heard, possession is 9/10 of the law. And that's especially true in commission disputes. Also like the IYBA, the deposit is negotiable, so it gives the buyer additional flexibility. Looking now at the IYBA, the deposit is due within 4 banking days. The deposit is held by the stakeholder, which is the broker listed as broker 1 on the contract. Excuse me. This is usually the listing broker, but it can be negotiated. However, giving the seller the option to have the buyer's funds held by the listing broker will usually be a point that you have to negotiate and could lose if you're representing a buyer, so be prepared for that. The other significant point as it relates to the deposit is that under the IYBA and the IYBA, the selling broker gets to pay the commission out of the deposit, where in the IYBA, the deposit is paid to the seller with the rest of the proceeds. So you as the broker, under the IYBA and the IYBA, can pay your commission right out of the deposit. Under the IYBA, you can't. You're not authorized. To summarize, the IYBA provides the most flexibility and commercially reasonable terms. The IYBA is a close second, but as I mentioned, I'd recommend amending to give your buyer more time to make the deposit. And the IYBA is the least flexible, with the possibility for dispute over who holds the deposit and for how much the deposit is. Now let's look at how the forms handle what happens if a buyer doesn't pay a deposit. So we regularly say that on the one hand, the IYBA is a buyer-friendly form, and on the other, the IYBA is the seller-friendly form, which in most respects is true. But the key here is the IYBA is a buyer-friendly form to serious buyers, not buyers who are going to waste your time. Why? Well, under the IYBA, if the buyer doesn't pay the deposit, the buyer agrees to pay agreed and liquidated damages to the seller and the brokers the amount of the deposit. 50% to the seller, 25% to each broker. I call this the hammer. And it holds the buyer accountable and prevents frivolous offers that tie up boats. How does the IYBA handle it? Actually, I want to come back to that one. Under the IYBA, I'd say the IYBA has no hammer. Why? Under the IYBA, the buyer fails to make the deposit, the seller can cancel, and has a claim for provable losses and expenses reasonably incurred. Good luck to the seller proving his losses and not going broke paying a lawyer to try to prove those damages. The IYBA has no hammer. Which brings us back to the IYBA. That's actually silent on the issue. It doesn't say. So you're actually in the same position as the IYBA, trying to prove your damages in front of a court. So in essence, IYBA has no hammer either. Okay. So if I lost you before on this deposit stuff, that's okay. But this is the part that I think you need to pay attention to. This is where you as a broker can get tripped up. This is where you can have a client accepting a boat that they didn't intend to accept. And so this is the stuff that I really recommend you take away. So looking at the terms associated with the sea trial, survey, and acceptance, all three forms are generally the same in this regard. Okay, you have the running risks that are of any sea trial borne by the seller. The risk of loss remains with the seller until closing. Note that there's a little wonky provision in the IYBA that we'll discuss soon. And survey costs are generally the responsibility of the buyer. Standard stuff, right? However, the IYBA differs drastically from the IYBA and the IYBA on how sea trials and surveys are treated and the effect they have on the rest of the deal. Under the IYBA and the IYBA, the forms are generally the same in that the buyer may perform a survey and sea trial. And pending the results, the buyer may tender his acceptance or rejection. But the key is, under the IYBA and the IYBA, the buyer must affirmatively accept the boat or it's deemed rejected. Okay? That is the key. If the buyer does not transmit acceptance, the boat is deemed rejected. The contract is canceled, deposits are returned, and everybody goes on their way. Oh, and I said that the IYBA and the IYBA are actually generally the same. The IYBA doesn't actually guarantee the right of the buyer to sea trial the boat, which is interesting. And I checked this a few times. It implies it, but it doesn't actually expressly state that the buyer can sea trial the boat. Now, if it's something that's up for debate, it can generally be something that evolves into a dispute, which is why I'm highlighting it for you. The reality of the situation is, if the seller doesn't allow the buyer to sea trial the boat, the buyer rejects the boat, and the deal's dead. But just wanted to let you know. So, again, this is the key. Keep in mind that under the IYBA, if the buyer does not transmit notice of rejection, he's deemed to have accepted the boat. It's the exact inverse case here. Now, that's not the only thing that can trip you up. And I'll get to that in just a moment. But under the MIBA, the procedure for sea trial and survey are bifurcated. They're completely separated, and the sea trial has to come first, and the survey comes second. And this is where it gets tricky. I'm telling you that you have to be prepared and understand this procedure, or you can end up with a client who falls into one of the traps I'm about to discuss with you and ends up accepting a boat he didn't mean to accept. So the first trap. So let's say our buyer decides not to do a sea trial, which, it could happen. The MIBA states that he's deemed to have accepted the boat subject only to the condition survey. Now let me say that again. Under the MIBA, if the buyer does not sea trial the boat, he's deemed to have accepted the boat subject only to the condition survey. And I'm going to tell you right now that the condition survey does not give your client flexibility to back out for any reason like the IYBA and the YABA. In fact, the MIBA states that the buyer can only back out for defects, which is a term of art defined in the contract. So let's look at this together. A defect, under Clause 27, a defect shall be regarded as a defect for the purposes of this Clause 27 if an officially appointed marine surveyor, to be defined as a marine surveyor whose day-to-day business is occupied with the surveying of vessels of a similar quality to and value of the vessel, shall have certified in writing that the defects affects the operational integrity of the vessel or her machinery or her systems or renders the vessel unseaworthy. So what does this mean? Well, it means you won't be able to call up your friend, the surveyor, to look at the boat, because there's probably going to be an argument about whether they're qualified and they have the right credentials. And when I say friend, I mean qualified surveyor that you use regularly and you trust. It also means the possibility of argument over something that affects the operational integrity of the vessel or its machinery. I'm not even going to try to figure out what that means. I'm guessing it's something catastrophic, like a hole in the side of the boat or blown engines. And then there's the possibility of argument over whether something affects seaworthiness. Now, you might be wondering, is that it? Doesn't seem too bad. Well, I'm going to tell you that we're only talking about the first of 3 traps here. And no, that's not it for trap number 1. The term defects does not include defects that were disclosed to the buyer prior to the contract, prior to signing the contract, before the survey. So before you get an opportunity to see what the defect is, to really, he tells you something happened, there's something wrong with the boat, before you really get to dig in and see what it is and inspect it, you've already been deemed to accept it. That's a big one. So this means we're also having arguments about whether something was disclosed. And I'm of the opinion that this clause was made overly complicated. I'm talking about this whole section 27, to keep the lawyers in business. And I don't mean the American lawyers, but I'll talk more about that later. So if that wasn't enough, worrisome enough, rather, let's talk about trap number 2. This time, let's pretend your client sea trials the boat. So you think, okay, he's no longer deemed to have accepted the boat, which is good. But does he now have the option to walk away like the IYBA and the YABA? And the answer is, well, it depends. And it depends on what happens after the sea trial. So let's look at this together. Clause 26 states, notwithstanding what is contained elsewhere in this agreement, if for any reason whatsoever and in his discretion, the buyer considers that the vessel has not performed to his satisfaction on the sea trial, and he does not therefore wish to proceed with the purchase, he shall give written notice of his rejection of the vessel to the seller or the broker, and this is the key, within 24 hours of completion of the sea trial or prior to placing the vessel ashore for the condition surveys, whichever shall be sooner. Okay, so that's a little loaded, right? Let's unpack that a bit. It basically says your buyer has 24 hours from the completion of the survey to tender rejection of the vessel, or in the event that the boat is going to be hauled out for a survey, if it's less than 24 hours, before that takes place. So it's a period that can be considerably shorter than 24 hours, and if you don't tender the rejection, your buyer is deemed to have accepted the vessel, subject only to the condition survey, which, as we just discussed, has plenty of pitfalls of its own. The other thing I'd like to point out is that this 24-hour window means that your client is not going to have the opportunity to receive and review any written findings, any report that's generated during the sea trial. There's just not enough time. It's 24 hours. On the other hand, if you give notice of rejection before the condition survey takes place and within 24 hours of the sea trial, then your client has safely and properly rejected the boat. However, if your client doesn't, then we're back in trap number one, where they've accepted the boat, and you have to now argue over whether these defects, if there are any, are going to give you a reason for your buyer to back out in case they have a change of heart. Now this one's one of my favorite, or it is my favorite. So this is the third and final trap, which, unless you've experienced it, it's not totally obvious on the face of the contract. I mean, it's clause 9, looks harmless. Sea trial and condition survey to be completed no later than insert date here. Well, we just discussed that the sea trial has to take place before the survey, right? And what happens if you can't get all your ducks in a row and you can't get the survey scheduled before the last day of the deadline there? Well, since the survey has to proceed, since the sea trial has to precede the survey, you've basically just waived your right to a survey because you're not getting a sea trial and a survey done in the same day. So you've just fell into a third trap. And assuming you do get it done, the sea trial done on the last day, you then have to be rushing to tender your rejection of the boat, or you have to execute an addendum to try to get your buyer the opportunity to have the option to survey the vessel again. It's just not a good situation to be in. So in practical terms, the way I see it is the 24-hour deadline, which if you miss could get your client stuck, is simply draconian and invites disaster. And if you don't cancel in writing, your client can't later say, well, my wife doesn't like the boat, or I'm not going to be able to cover the cost. It's costing more than what I thought it was going to take to redecorate or refit it. And they won't have the option to walk away because the layout and the decor have nothing to do with the operational integrity of the boat, its machinery, or its seaworthiness. So the bottom line is, avoid the MIBA if you can, but if you have to use it and you don't have a lawyer involved before you sign, don't make an offer unless your client is prepared to accept the boat as is, but for major mechanical issues. In simplest terms, under the IYBA and the YABA, a buyer has to affirmatively accept or the deal is dead. Under the MIBA, a buyer has to affirmatively reject or the deal is on. And if you miss the sea trial rejection deadline, it's very difficult to reject the boat after the condition survey. Oh, and remember when we were discussing that risk of loss remains with the seller in the beginning, right? Standard terms that we're all used to seeing. I mean, it makes sense, right? The seller is going to maintain insurance on the boat till closing. Well, the MIBA has this wonky provision here that if the buyer rejects the boat and there was some damage caused by the buyer his representative, or the captain of the boat during the sea trial, the buyer has to pay for it. Frankly, that's ludicrous. And it just gives you the potential to lead to some really upsetting outcomes with your client. I mean, really, it's not just damage that was caused by the buyer's representative, but the captain, the master of the vessel. I would be really wary of this clause and would implore you to have this amended out if you're dealing with amoeba. In 99.9 out of 100 times, nothing's gonna happen. But do you wanna take the chance of being the broker involved the time that it does? I mean, insane. So, how are we doing on time here? Good? Okay. So let's talk quickly about choice of law and venue. Choice of law is what the law of the court or arbitral body will use when deciding a dispute. For example, the laws of the state of Florida. Venue, on the other hand, is where the actual dispute is going to be resolved. For example, here in Fort Lauderdale, Florida. And each contract has significantly different choice of law and venue provisions. So under the IYBA, you actually have a few options. Florida is the default. If you don't check any of the boxes, you just sign the form, fill in the major parts of the deal, leave everything blank. You're going to be selecting Florida choice of law. Other states are also an option under the IYBA. You can fill in whatever state the parties choose. Or you can choose English law if you want to go to arbitration. If you just end up selecting dispute resolution through arbitration, one of the options you have is to go to the UK and dispute it under English law. Venue's Florida by default. Similar to choice of law, you basically have full flexibility on what the buyer and the seller want to do. Oop. Under the IYBA, it's actually really tricky. So under the IYBA, choice of law is the state of the listing broker's principal office. Now, in the law, a principal office is a term of art. It means the headquarters of the company, where the heart of the company is, and where it operates out of. So it's not just a principal office in Florida, right? If the brokerage has multiple offices, could be a principal office if based out of Maine, but we'll talk more about that later. The other thing is that venue is the county of the listing broker's office. So a listing broker, that's just if you're working for a large brokerage and you're working out of a satellite office, it's not the main, it's not the principal office, that's where the dispute's gonna be resolved. So you can see how you might end up in Florida if you're the listing broker in Florida, but the headquarter of the brokerage isn't in Maine. You could be in Florida applying Maine law, potentially. Now under the IYBA, you're actually stuck in arbitration, but you're doing mediation then arbitration, but same event. You're having people who are presumptively experts within their state deciding matters of other states' laws. It just leads to a result that, in my opinion, is not ideal. So now I do want to make a point though, it can be beneficial for you as a broker, this provision, because assuming your principal office is located in a state where the law is very broker friendly, right? Then, you presumptively want these terms, right? You want the choice of law to be the principal office. Now, I don't know many brokerages that started up just because they wanted to take advantage of a state's laws. I think what we do is better lobby the state to change the laws to make it more broker friendly, right, Paul? So it has a benefit, but I can see, in most cases, I don't think it's going to achieve that purpose. And the reality is it can lead to less than ideal outcomes. Now, the amoeba is pretty straightforward. It's English law, and you're going to England. That's it.
I just want to interrupt real quickly, Adrian. And in the IYBA agreement, I mentioned it earlier this morning, but there is a review in process right this minute of the language that I'm sure you're familiar with. Article 17 will be our dispute resolution and the default platform for dispute resolution will be the International Yacht Arbitration Council, and the manner will be through arbitration. You will have the ability to select state law, or you could do the American Arbitration Association or London Maritime. You could do anything you wanted to. But if you do nothing, then the default platform will be IYAC, and it will be through arbitration.
Perfect. So that
We thought so.
yeah. So I actually was going to mention IYAC at some point. I didn't have the latest from you, Paul, so thank you for that. So I wouldn't say throw out what I'm going to show you on the next slide, but keep it in mind because we are going to talk about dispute resolution. So let's see where we are. Dispute resolution, perfect segue. So there we go. Okay, so under the IYBA, mediation is not an option currently. It's not required of you. The parties can always voluntarily agree to do whatever they want, but it's not something you're contractually obligated to. Taking what Paul just said, traditional litigation is no longer going to be the default. It's an option, but not the default option, correct. And arbitration is going to be the default option, and you have the choice of either being here in the US or you can go to the UK and be governed by English law. Or Monaco. The IYBA, on the other hand, requires mediation. Traditional litigation through the courts is not an option, and arbitration is required, but only after mediation. And in this specific case, the parties have to, under the IYBA contract, mediate or attempt to mediate for at least 60 days or before they're able to actually take the case to arbitration. So, if you can get a mediation done within 60 days, great. But you have to at least mediate or wait 60 days before you can actually get to, before somebody who can make a final decision. Because mediation is non-binding. And that means that whatever the mediator recommends or whatever the parties come to discuss is not going to, unless you reach a settlement agreement, it's not done. You have to go to arbitration. So I'm not going to say that it's the worst provision, for the IYBA. Sorry, let me back up. I'm not going to say that's the worst provision. Mediation does work, generally, and I'm not talking just within the yacht space. I mean, having the parties show their cards, engage in good faith discussions does help resolve disputes. I just personally think having to potentially wait 60 days before you can get a case started in arbitration it's not what I would recommend, not what I would choose to do. Because you can be in arbitration for, depending on the issue, you can be in there for years. So it can be just as slow as traditional litigation. Depends on who the arbitral body is, of course. If you have specialists like the IYAC, then things presumptively will move along quicker. But if you're in the AAA, just general commercial rules, you could be there for a while depending on what the issues are. And so now to the MIBA, the only option is arbitration. And as we mentioned, you're going to be in the UK. And I don't know if you recall earlier, but I said that MIBA Clause 27 was written to keep the lawyers in business and not the American lawyers. And this is the reason, because the only lawyer that's going to be dealing with is a lawyer in the UK, because that's your only option under the contract. So we're about at the tail end of our time together here, and so sorry if you dozed off. I told you I wasn't making any promises. And to conclude on most things, the three agreements are essentially the same, but there are important differences deliberately set up to trap buyers, specifically in the MIBA. And the three forms all have you, the brokers, in mind, and they all grant you significant legal protections. So if you're going to use none, I'd recommend one of them. Don't start from scratch. And with that said, the IYBA form is better and keeps getting better. So make sure you have the latest version and use it.
Does anybody have any questions for Adrian? Hang on a second.
If your client decides to reject the boat, just say one of the main engines is bad, I had heard years ago that the seller has the ability to remedy whatever that problem is before you reject it. Is that true?
Under which form are you talking about?
MIBA.
Under the MIBA, it depends if, I do not believe it's true. I think it has to be something, sorry, repeat your question? I got hung up on which
All
form.
right, so
we're
I'm trying to buy a
compartmentalize.
45-meter boat and we reject it because it's got a bad main engine. We ran into this a couple of years ago where we were being told that the seller can remedy that problem and still keep the boat in play.
So the EBA definitely has that provision, I'll tell you. If it's less than 5% of the value of the purchase price, you can definitely remedy. I don't believe the MIBA has that, and I'm pretty sure the YABA doesn't have that either. But I'll check, and we can discuss. I have the form there, and we'll look at it together.
One over here. Who had a question on this side?
Dan behind me too, but I'm not sure who came in first.
Okay. John Henry's got seniority.
You said that the selling broker holds the deposit, but it seems to work out normally the buying broker holds the deposit.
So I'm contrasting selling broker and listing broker. So the selling broker is a broker who brings the buyer to the purchase. The listing broker under the contract is the one who has the listing for the seller.
Okay. Yeah. What?
He's using the yacht closer.
Okay. Thank you.
It's all Greek to me. Who else has a question? Oh, hang on.
The aforesaid rejection form within the 24 hours, since it all seems to be a little tricky, does the sender need to prove that it was received by the person who it was sent to?
Can you repeat the first part of your question? I had
Yeah,
difficulty
the
hearing.
rejection form after the 24 hours, the sender of the rejection, let's say buyer side, need to prove that it was received? Or can the receiver say, well, I've never received it within 24 hours, sorry about the boat? Or
So you send it in writing to the seller's representative or the seller directly. I'd say both if you have the opportunity to do both. And of course, it's good business practice to follow up, especially when you're under such a time constraint. But it doesn't require you to confirm that they've received it. But I would say you should do it. You should definitely make sure you don't get stuck.
One more question for Mark.
So, under the concept of offer acceptance performance as the basis of a contract, the MIBA on the deposit part, it says upon execution. So the moment that the deposit's received in the, I guess, selling broker's account is when the execution happens. That's when the clock starts. Or
So that's why it's tricky, and that's why I explained that you could have a buyer who's in breach, and I said that the contract could just be dead ab initio, which means right off the bat it doesn't never take off, because upon execution means at the same time. So presumptively you'd want the deposit to already be in the selling broker's account when you send the contract, right, to the seller. Now I don't think, I've seen everything in litigation, but I don't think if you didn't have the deposit at that moment, the seller would try to kill the deal. But it's something that is potential, right? You don't want to have yourself in that position, which is why I say just amend it, make it 3 business days, whatever you guys need. I would not operate with the way it is, because it leaves you open to potentially not having a deal, or worse, because the time is of the essence clause that's in the contract. You have a buyer that's in breach, which is not the way to start off a deal.
No doubt. All right, Adrian, thank you very much.
Thank you.
It's tough to make that interesting, and you did a great job. Thank you. Bob, you want me to take him to break? Okay. We're going to take a break. Just please keep in mind that one of the most important things here is your pink sheets. Thank you very much. Pink sheets. The way we build these seminars is on your feedback. The information that you give us helps us bring you excellent content. And you don't get drinks at the cocktail party if you don't turn in your pink sheet. So no incentive there. We'll see you back here in about 20 minutes. There's snacks and coffee and such out in the lobby.